Welcome, everyone. Thank you for joining us for our bi-monthly wealth and webinar series here. This is Andrew Rosen, one of the partners of Diversify. As you all know, today's topic is the essential estate planning documents that we need. We are pleased to have join us today one of Diversify's good friends, Michael Salad Esquire, one of the partners at Cooper Levinson. He's worked with a bunch of our clients and friends in the past. We're going to allow questions through the message board. So if you have questions as you go, please feel free to ask them through the message board, and then we'll take them as they come and weave it into Mike's presentation. We like to keep these things efficient. We'll be done at 12:30 sharp, we will aim for. We'll also send around the follow-up recording after the fact. And just so everyone can note our next big event here, or webinar, we have our mid-year economic and market update by our own Mike Horwath, and that is on August 8th at noon. So you can mark your calendar, share with your friends, whatever works best for you. So with that said, the essential estate plan and documents everyone needs. Michael, you're with us?
I am.
Excellent. So I'll turn it to you, as this is a question we often get about, what is estate plan and what do we need, and I think there's even some confusion on what it is in general, how it differs in just getting wills done. So start us off, and I'll chime in as they have questions, or I'd like you to elaborate a little.
You got it. Thank you very much, Andrew. I really appreciate the partnership that we've been able to establish, and I very much appreciate this opportunity to speak with you and your clients today. What we're going to discuss is real basics today. We're not going to get into any of the nitty-gritty and try to keep it pretty light, but we are going to discuss a couple of the core essential documents that comprise an estate plan. So what is an estate plan? An estate plan sounds like it's very complex and can be very expensive and overwhelming, but it really isn't. It is the process that you go through in planning not only for death, but if you become incapacitated, and who would be able to carry on your day-to-day affairs if you're unable to do so. The first core document that we're going to discuss is the last will and testament, which is the most basic and the primary document that controls most of our clients' estate plans. It not only will outline how you wish to dispose of your assets upon you passing away, but it also requires you to appoint an executor, also known as an administrator or personal representative in other states, and that is the person who will administer your last will and testament through the probate process that we're going to discuss. For those that have children that are unemancipated under the age of 18 years of age, one of the key components of a last will and testament is appointing a guardian. The guardian is the individual who will be legally responsible for your minors if you predecease them and minors are under age 18. One of the common misconceptions is that if you appoint a guardian, that person is automatically going to serve as the guardian of your children if they are minors when you pass away. But in fact, actually what happens is that a judge will make that final decision. They look very heavily upon whom you recommend in your will, but it is simply that, a recommendation, and then needs to ultimately be approved by the court. And then you also generally will appoint a trustee within a will. Now, trustee is commonly associated with a trust, which we're going to briefly discuss, but a trustee is also used in a will in what's called a testamentary trust provision, which is simply a trust that is created within a will. So if you have children that are under certain ages, at your discretion, you may wish to hold assets in a trust for their benefit. And people hear the word trust and they think, wow, that sounds like a very involved and expensive process. but it really isn't. A testamentary trust is as simple as a couple of paragraphs within your last will and testament that state that if my children under a certain age or any other beneficiary, grandchildren, nieces, nephews, etc., are under a certain age or ages, we may wish to hold those assets for their benefit in trust. And the trustee is the person who is responsible for overseeing the administration of the trust and distributing the assets to the beneficiaries of that trust.
Michael.
Yes.
Question for you that I often get, I think we all often get here at Diversified. So do you recommend the executor, the guardian, the trustee be the same person, different people? Is there criteria you would assign to who the executor should be, who the guardian should be, who the trustee should be?
It's a good question. It's a very good question, and it does come up. And the answer is I am not opposed to the same person being appointed in all three of those capacities or two of the three. They are slightly different roles. The trustee and the executor, I want someone with a little bit of fiduciary background or sense, meaning that they are familiar with managing money. They are able to maintain their own assets and day-to-day affairs fairly prudently and efficiently. That's most important, particularly with the trustee, that they know how to manage money. The executor role, frankly, Andrew, is not all that important because it's usually the person who calls the attorney and they handle a lot of the legwork. The guardian, on the other hand, is generally someone that when I recommend a guardian, it's the person that knows your children or child very well. They know their tendencies and their patterns and behaviors, and it is someone that is strictly going to be responsible for their well-being as opposed to any of the monetary issues. Makes sense.
And as far as a trustee, it can be a person or an entity, unlike the others. That's true, correct?
Correct. A trustee can be a corporate trustee. So you could say SEI Trust Company, for instance, could come in as a corporate trustee. The benefits of a corporate trustee are that you would have people who are going to do this for a living. This is what they do. They administer trusts and they know the inner workings of a trust document and really know how to properly manage a trust. The downside of a corporate trustee is that there's usually an added expense, and also you usually have to go through a committee to get anything accomplished. So if my child goes to the trustee tomorrow and says, Dad said this trust, I'm supposed to get funds at your discretion, and I want to go to college and I need the funds, a committee will be convened, and usually a panel of 3 to 5 people within, in my example, SEI Trust Company, to make that decision. So there's a little bit of administrative burden. But a corporate trustee a corporate entity can also serve as an executor. While I discourage it, I usually recommend an individual, mostly because the fees are high. A corporation can serve as executor as well.
Understood. Thank you.
You got it. Next slide is fairly simple, the separate memorandum. I have a lot of clients that come to us and they say, I've got baseball cards, coin collection, a doll collection, any number of things that may be important to them, but may not have a lot of monetary value, and they may wish to dispose of these assets at different times through their life. They may want to update it, and instead of having to go through the formal process of updating a will, a last will and testament, they may wish to do so through a separate document. In our surrounding states, in Delaware and New Jersey, separate memorandums are specifically provided by law, and it outlines how you can do so. In Pennsylvania, there is no specific statute that governs how a separate memorandum is established, but there is a body of cases in Pennsylvania that specifically permit memorandums. Popular will provisions. I'm going to just talk in general. The disclaimer trust is one of the most common because it allows an individual to disclaim assets, meaning not receive assets, and then they can be passed into a trust. So the most common way that we use this is if a husband and wife they establish an estate plan and they decide that they're going to use disclaimer provisions, all of the funds that the spouse who survives, the other spouse, would receive, would have the option of disclaiming the assets to be held in this trust for that spouse's benefit. So Andrew and Jessica are married, and Andrew has a disclaimer trust provision in his will, and it says that upon him passing away, all of his assets will pass to his wife, Jessica. If Jessica is not doesn't want to receive the assets, and we're going to talk about why that may be, they can pass into this disclaimer trust for her benefit for her lifetime, and there would be a trustee that Andrew can appoint in his will to oversee those assets. The most common reason that we use a disclaimer trust is twofold. One, there may be tax benefits to doing so. For instance, in New Jersey, there used to only be, just a couple of years ago, a $675,000 exemption from estate tax. We're going to discuss what that is, but it is, in its simplest terms, a tax that is imposed upon your estate, which your estate comprises all of your assets when you pass away. So if you use this and implement this disclaimer trust, that $675,000 exemption can be doubled by using this disclaimer trust. In more simpler terms and more common ways that we use the disclaimer trust is if one spouse has creditor issues. So let's say in my example of Andrew and Jessica that Andrew has creditors and they've been coming after him, and now Jessica passes away first, and if all the money that was in the estate of Jessica passes to Andrew, his creditors are going to be able to grab all of those funds. By using this disclaimer trust, because the funds don't pass to him directly, they pass to this trust for his benefit, the creditors will not be able to gain access to to the funds that would have been left for him outright. So similar to the testamentary trust, it's just a couple of paragraphs within a will. It's a very simple provision to include. There's absolutely no downside. If the spouse wants to receive all the money outright, he or she can do so. And if there's a need for it, you can implement this disclaimer trust provision. It is strictly discretionary at the spouse's discretion.
And Michael, I do appreciate you protecting myself from all these creditors, so thank you.
I was just picking two names in general. That wasn't specifically you, Andrew.
Thanks.
Of course. The testamentary trust we discussed a little bit, and I'm going to discuss the pour-over will next. If you recall in the very beginning, I said that there is also a use of a revocable trust. And a revocable trust, well, I'll skip that a bit, is a similar document to a will, but it is created and implemented during your lifetime. So the benefit of a revocable trust is that you will not have, your estate will not have to go through probate for any assets held in a revocable trust. It also gives you full access to all the funds that are in the revocable trust while you are living. Back to my example, Andrew and Jessica set up a revocable trust, and they transfer all of their bank accounts and other assets, their real estate, into a revocable trust. They will have full discretion to use all of those assets during their lifetimes, just as they were while it was in their names alone. The only difference is that when they pass away, there will be no need to open up probate administration. So in some of our states where there is difficult probate processes, such as Florida, where I'm licensed and I handle a lot of probate, the process is horrific. So even if you just own one piece of property and it's a vacation home in Florida, and then you have your primary residence in the Northeast, there is significant benefits to transferring that property in Florida into a revocable trust to avoid probate administration.
Right.
The pour-over will simply states that all of the assets that are in your names at the time of death pass into your revocable trust. Now, it's a catch-all, but it is very important that you transfer all of your non-retirement accounts, which we'll discuss separately, from your names into this trust during your lifetime. Because while the pour-over will is a catch-all and will transfer any other assets that you owned in your name at the time that you pass away into your revocable trust, you will have to still go through probate in order to do so.
Michael,
One,
you hit on something there. Are there assets you don't recommend being in trust?
yes, and particularly a revocable trust, and that is retirement accounts. Anything that is a qualified account, we call qualified accounts, such as a 401k, an IRA, whether it's a traditional or Roth, 403b, etc. Those 457, on and on, all of those qualified accounts, we do not want to transfer into a revocable trust. And while it is a very complex area of the law, I will just keep it in a very granular, in a very basic level here, that if you transfer a retirement account into a revocable trust, the capital gains taxes that will be incurred by your beneficiaries are significantly more than it would be in the situation in which you appoint a direct beneficiary. So take the example of Andrew owns an IRA, and he appoints to his children as the beneficiaries. If he were to appoint his revocable trust as the beneficiary, and that revocable trust owns that IRA for the benefit of his children, all of the distributions from the IRA would have to be made within 5 years. Whereas if he just appoints his children as the beneficiaries directly, they can defer the capital gains taxes using their measuring life, their lifetimes.
So are there ways to protect retirement accounts above and beyond trust planning?
It's another great question. There absolutely are. So instead of a revocable trust, we can use a retirement trust. It is more technically generally referred to as a conduit trust or an accumulation trust. And the differences between them are probably outside the scope of this webinar, but it allows your beneficiaries to enjoy the capital gains deferral and also hold those assets for their benefit in trust if you are concerned that the children are too young to receive substantial assets from a retirement account.
Okay, so is there ways to make a revocable trust as a beneficiary without the issues you mentioned, or is it the conduit trust is that way?
What you can do is you can include a conduit trust or an accumulation trust provision within the revocable trust. So you can have separate provisions, but the key is that you need to have a separate conduit trust or accumulation trust within the revocable trust for each beneficiary. So if there are, say, 3 children, Andrew has 3 children, and he wants to set up this retirement trust within his revocable trust, he needs to ensure that there are 3 separate trust provisions and paragraphs within the revocable trust, one for each of his children. Make sense?
Yes, thank you.
Okay. One other point, since you guys are in Delaware, and I will disclose I am not licensed in Delaware. We have an office there, and I've been a part of many matters there. And in Delaware, there is this 1.75% closing fee that is assessed on probate matters. So we will often use a revocable trust as a workaround to avoid that 1.75% closing fee that is imposed on all probate estates in the state of Delaware. By simply transferring the assets into a revocable trust, there is no need for probate administration. Everything immediately passes under the trust without having to go through the expense and time of probate. Plus, you're going to avoid that 1.75% closing fee. So it's a neat trick that we like to implement with our clients in Delaware.
Awesome. Thank you.
I'm going to skip over the AB because it's a little bit complicated, and I feel like I've thrown a lot at you already. One of the other most common questions that I receive is, I'm a Delaware resident right now, Mike, but I'm getting close to retirement. I want to be in the sunshine of Florida or Texas or Nevada or another state where there's nice weather and very favorable tax laws. So I'm going through all this and paying you this money now to set up this whole estate plan. What happens if I moved? And that's a great question. And the answer is that under the full faith and credit clause of the United States Constitution, every state must honor the estate plan in which the initial estate plan was created. So let's use that example that Andrew is a Delaware resident and decides he's going to retire in Florida. And he signed his estate planning documents in Delaware, and he properly had it executed in the presence of 2 witnesses and a notary as required under Delaware law. Now he moves to Florida. And then he passes away, and Florida, the state of Florida, their probate courts are required to honor that his whole estate plan, including his power of attorney and his living will medical proxy, which we're going to discuss, and they must honor his wishes as long as the document was properly signed and executed in conformity with the laws in the state in which he was residing at the time that he did so, which in my example would be Delaware. One note is that there are certain states that we may want to adjust an estate plan a bit. So if you move, for instance, to a community property state, such as Texas or Nevada, that's again outside the scope of this webinar, but we may want to revisit your estate plan. And if you go to a state like Florida, where the probate process is very difficult, we may want to implement that revocable trust, whereas it is not as important in other states such as New Jersey and Pennsylvania, where the probate process is fairly simple. A similar rule applies for our international clients. We have a lot of clients that either own property overseas or they spend part or most of the year in another country. The laws of comity refer to the ability from one country to another to honor the estate planning documents in the country in which the documents were signed, again, in ensuring that those documents were executed properly in the country in which that person was when they were signed.
Michael, we have
Yes.
a lot of clients that have homes in PA and Jersey Shore, or Florida
Yes.
and Delaware. Is there a best practice or rule of thumb where to get those documents if they sort of cohabitate?
Yeah, so the first question I ask is, what address do you use on your tax returns? And that's usually my rule of thumb. There are some exceptions, particularly if you are in a state such as Florida where there's no income tax part of the year, and then you're in a state such as New Jersey where there's a very high income tax and you're trying to establish residency. That may change things, and that's a little bit complicated, but it's an area that I spend a lot of time with clients. That may impact things, but I generally will recommend that we go by the state in which you feel it is your domicile, meaning your permanent place of residence, which is usually the place that you use on your tax return, and that's the state that we should use.
Got it. All right, that's helpful.
Okay, so the next document is a living will, also called an advanced medical directive. There's a whole bunch of different names, but it is the document that allows an individual to appoint a medical proxy, a person to make end-of-life medical decisions. It is strictly end-of-life medical decisions, or if you are in some type of permanent vegetative state. The famous case is the Terry Schiavo case, where unfortunately Ms. Schiavo was kept in a vegetative state for a long, long period of time, but she did not have this document, and it ended up going through a long court battle. And it is a vitally important document because you want to ensure that you can dictate your wishes. Andrew and I have a lot of clients that fall in that middle ground where they tell us we want to live comfortably, and if there's a reasonable chance of survival, we want all reasonable medical services provided. But if beyond all reasonable medical certainty, there's absolutely no chance of survival, and I'm in pain and I'm in suffering and it's not a fun process, I want to be taken off life support. I don't want my life to be artificially prolonged. And so this document says that. The power of attorney will govern everything else that you may wish to have controlled if you're unable to do so. The power of attorney can cover everything under the sun except for 3 things, generally. You cannot allow someone to sign a new will for you, they cannot vote for you, and they cannot make end-of-life medical decisions for you, which would be covered by your living will. Other than that, you can make your power of attorney as broad or as narrow in scope as you wish, and it can be as simple as you going into a hospital for an operation, and you're not sure if you're going to be able to pay your life insurance premiums and your utility bills and your mortgage just for a brief period of time, and your power of attorney, your agent, can do so. Or you can also plan for, and in the same document, if you are concerned that you will end up with dementia in the future and you don't have capacity anymore. It's a vitally important document because if you don't have this, then you have to go into court, and your family member will have to go into court and go through a very public and expensive and long court proceeding to be appointed as a guardian. We discussed the revocable trust. I'm just going to go through a couple of other estate planning considerations, and if we have any questions, would certainly welcome them. But it's really important. The one takeaway is that you really want to spend the time now so that your beneficiaries do not have to go through a very long process in the future that is very expensive. And the best way to do that is to ensure that you have proper beneficiary designations. And if you have a revocable trust, you want to make sure the trust is the beneficiary on all non-qualified assets. And if you don't, you want to make sure that you have all of your designations properly denoted on your life insurance policies, on every other asset that you own. I really think that's the number one key takeaway of today. And that's really all I have. The elective share is a little bit complicated. Rather save a couple minutes here and see if there's any questions.
Yeah, Mike, I see you have life insurance and ILET there. A couple quick questions there. First of all,
sure.
Help us understand, does life insurance in general fall into your estate? And also, when do you recommend putting life insurance into a trust, like a life insurance ILET or life insurance trust versus not?
Yes, great question. And the answer is that the life insurance policy becomes part of your estate if you do not appoint a beneficiary. That can be you name a beneficiary, but that person is deceased, or you appoint a trust or a trust within a will that no longer exists, that you terminated. So now it has to pass through your estate. That is the worst case scenario of life insurance. You always want to ensure that you, at minimum, have a beneficiary designation, meaning your spouse, your children, whomever you wish. But the better alternative is this ILET, an irrevocable life insurance trust. The reason that we don't use them 100% of the time is because it is a separate trust and there is an expense setting it up, and there's an administrative burden of going through paperwork with the insurance carrier to transfer a policy or to write it through a life insurance trust. And you also have to set up a separate bank account, and the premiums have to be paid into the bank account and then to the insurance carrier. So I wouldn't say Andrew, there's one hard and fast rule where if you have X amount of life insurance, you should use it. But I am seeing more and more of that situation that I just described, where someone appointed a trust within their will as the beneficiary of their life insurance policy, and then they signed a new will, and that made the policy pass under the estate because there was no beneficiary. So if you have a fairly significant estate, it is definitely, and you can afford to spend $1,000 or $1,500 that most attorneys generally charge for this, and you have a financial planner, I recommend you use the ILET because the financial planner can handle almost all of the administrative burden, and the expense will give you peace of mind that all of the life insurance proceeds will not only not pass through the estate, but they can be held in trust, and you have much better control over that policy. So I really do like and recommend a life insurance trust.
Right. Well, we'll have another minute or so here, Mike, but one or two final questions for you.
Sure.
One is how often or what needs to happen in your mind for people to update their estate documents? You know, a lot of clients come in here have a document from 10, 15, 20 years ago. Is there a rule of thumb you use?
I say it's a very organic process, and I like my clients to check in with me every year, every couple years, let me know if there's any significant updates in your life. Certainly, if a spouse passes away, or a child or other beneficiary, or your executor that you have appointed passed away, uh, or you have a child now and you need to appoint a guardian, that's a no-brainer. That's the time to update it. If you see in the news that there's a significant change to the tax laws, like there was last year, where there's an overhaul of the estate tax, federally as well as in several states, that's a good opportunity just to have them looked at. And I know with me, and I know a lot of attorneys probably would do this, if you have existing estate planning documents, either call that attorney or find another attorney that does estate planning to review them. I certainly review all of any estate planning documents free of charge, just to take a look and make sure that there aren't any glaring issues. But if there is a life event, some type of significant change in your life, that's definitely a key. But I'd say every 3 to 5 years, you really should be taking a look.
Great, real helpful. Okay, I think final question for you, and then we'll let you get on with your day and all these fine people. So the cost. So I know it can range, but I'm sure many people that are listening and will hear this are curious.
Mm-hmm.
What is the range for a married couple to get this slew of documents?
Yep.
In
For sure. So for like a last will and testament, a revocable trust may or may not be a part of it, a living will and power of attorney, we're generally talking about $2,500 type of thing. The part that is a little bit unknown is what type of assets they hold that may need to be transferred. So for instance, a lot of times we transfer real estate from a husband and wife or just one person into a revocable trust. So there's going to be a cost to prepare the deed. It's nominal. It's maybe $250, $300. Sometimes there's a need to transfer something to an LLC, but that's a rough idea. It's usually between $2,000 and $3,000, soup to nuts. And I try to keep, as you know, Andrew, with your clients, we provide a discount off of our standard rates to all of your clients that we don't offer to anyone else.
Right, and that holds true for everyone at Diversified, so we appreciate that.
Of course.
Well, Michael, thank you for your time. Everyone
Thank
that's
you.
listening, thank you for your time. Certainly, if there's questions we haven't gotten to, we feel free to ask us. We can either answer them or get it to Mike. If you want to be connected to Michael or his firm, certainly we can help do that as well. And as he mentioned, he will gladly review any older documents anyone has free of charge, just to give his take on it. Again, our next webinar coming up August 8th at noon is our mid-year market update by our own investment specialist, Michael Horwath. He does a great job. Hope all of you can join us, and feel free to share today's webinar when we send it around with anyone that you think would appreciate it, as that's what we live to do. So thank you very much, and have a great Wednesday.
Thanks,
Bye.
Andrew. Take care, everyone. Bye-bye.